70%. So, yes, sir.
Yes. Good afternoon. Good afternoon. Nodidra textbook. I mean, did you read whatever I have done yesterday? You? Nodidra? Sorry?
I'm telling you about it.
Okay. You didn't take yesterday? Alright. You take today. It's fine. Okay. Yeah. Yesterday we started with historical background, right? So, what was the first act? Regulating Act of 1773, right? So, what was the important changes brought in? Bengal was renamed as Governor General of Bengal, right? Who was the first Governor General? Warren Hastings. Okay, fine. Yeah, one more thing. When you're reading history now, like for this exam, just focus on Vijayanagara. For this history part, if you see UPSC now, they are slowly shifting from north to south. If you see last 4 prelims, in every prelims there is 1 or 2 questions from Vijayanagara kingdom, right? So every prelims you take a 17, 18, 19, 20, 21, continuously you see the paper, there is at least 1 or 2 questions from Vijayanagara. So you can expect that here as well, right? You know, right? Vijayanagara kingdom, you also, you must be knowing, I mean all 3. It includes both Andhra Pradesh and Karnataka, right? So just go through that. Fine. So who was the first Governor General of Bengal? Warren Hastings. All right. Next is 1833. India. Who was the first Governor General of India? William Bentinck. He was famous for one more thing. What was that? What he did? Not with the act. Sati. He abolished Sati system. You know what is Sati system, right? Fine. Next, 1853, right? What is important in that? Open competition for civil service. Indians were allowed to come for civil service, right? So then it established a legislative council, 6 members legislative council. If I'm going fast, please stop me. Okay. Fine. Then who was the first? Then one committee formed. Which was that? Meghalaya Committee on Indian Civil Service, 1854. Right. Fine. Next, Government of India Act, 1858. Very important one, no? 1858. All right. So after that, it ended. East India Company rule, and the crown rule started in India. Means the India straight away came under the British crown, right? So it renamed, or it created a new position called Viceroy of India. He was the direct representative of crown, right? And next, they created a new body, Secretary of State. He was a part of British cabinet, who was accountable to British Parliament, right? So then next one, new body, 15-member Council of India. They created a new body called, never ever forget this act, man. It is damn important. Okay, if they decide to ask a question on this chapter, most probably they'll pick it from here, right? Fine. So Secretary of State, see, this is one is Viceroy, Council of Secretary of State, Council of India, Crown rule. Clear? Who was the first Viceroy? Canning, right? Canning was the first Viceroy. He was the Governor General during First War of Independence as well, right? Fine. So next is 1909. Yeah, Morley Minto reforms, right? Morley was the Secretary of State, Minto was the Viceroy of India. Important thing is, separate electorates or communal representation. Separate electorate. Minto was the father of separate electorates or communal representation, right? So they started separate electorates here in 1909 Act, right? So, and in that act, Indians were allowed to be a part of Viceroy's Executive Council. Satyendra Prasad Sinha became first law member, right? Fine. So 1919 Montagu-Chelmsford reforms are Government of India Act, right? Or Montagu-Chelmsford reforms. Montagu was the Secretary of State, Chelmsford was the Viceroy, right? So in this act, what is the important thing? Diarchy was very good. Diarchy was introduced in provinces and bicameralism at center. Then they divide the subjects into two lists. That is in provinces, reserved and transferred. Center, two lists, federal and provincial. Done. Next is, and one more thing, it allowed for establishment of, what was that? Yeah, Public Service Commission. PSC. I mean, current UPSC is there now. So before independence, that was British Public Service Commission, Indian Public Service Commission. All right. So that was established in when? 19? Provincial. Yeah. See, they divide lists into federal, provincial. Right. These provincial lists were again subdivided into reserved, transferred. Reserved were administered by governor with the help of Executive Council. Transferred lists were by popular ministers. They were accountable to the House. That's all. Understood now? So, it is not fast, right? Yeah, done. So this is transferred. So I asked one question, right? Yeah, Public Service Commission. When it was established? 6. Very good. 1926. So next is, bicameral legislature at center, right? Government of India Act 1935. What is the important thing here? One more thing. I think yesterday I tell you, it established an Indian Federation. Yeah, Indian Federation. It included all the British Indian provinces, Chief Commissioner provinces. They included all the thing and created a federation. Means currently we have an Indian Union government, na? Like that they include all the provinces and created Indian Federation, but it never came up because there was a conflict between the provinces. It never came up. Practically, it was not implemented, but the Act had that provision. Okay, so important thing is diarchy was abolished and replaced with provincial autonomy, right? And diarchy was introduced at center. Diarchy was there in province. they abolished diarchy and established provincial autonomy, and they introduced diarchy at center. Got it, no? And next thing is public service commissions in provinces, right? Provincial public service commission was allowed to establish. Clear? Then bicameralism in 6 out of 11 provinces. And one more thing is they act divided the subjects into 3 lists. Earlier there was in 1919 Act 2 lists: federal list, provincial list. Now federal list, provincial list, and concurrent list. Clear? Act allowed for 3 lists. You're getting the difference, right? Because you should not get confused between 1919 Act and 1935 Act. 1919 Act, they divided the subjects into 2 lists. 35, 3 lists. 1919 Act, they introduced bicameralism at center. 1935 Act, provinces. And 1919 Act, they introduced diarchy at provinces. 1935 Act, they introduced diarchy at center. Yeah, here they cancelled. They introduced at center. Provinces they cancelled. They replaced with provincial autonomy. Got it? Fine. Sorry? Federal, provincial, and concurrent. Concurrent list. Clear? Fine. Next. Yeah. Sorry? Yeah, 1947 Government of India Act. There's nothing much. You will read in detail in history, actually. 1947 Act, what happened before that, Cabinet Mission, Cripps Mission, August Offer, Wavell's Plan, all those things. That is related to history. And Simon Commission. Simon Commission also I told you yesterday. It was formed, actually, I forgot to tell you one more thing, I guess. In 1919 Act, it allowed for establishing a statutory commission to review the performance of the Act after 10 years. That is why Simon Commission was formed. And the 1919 Act was introduced. How it will perform, the diarchy, especially the diarchy, how diarchy will perform in the provinces. To study that, the Act allowed to establish a statutory commission after 10 years. So it was supposed to be formed in 1919, but British government formed it in 1926. So that committee, it is not required in polity, it required in history actually. So they appointed a commission in 1926 to check how the diarchy is functioning. Okay. So Simon, go back, those movement and all, you remember, right? In history you must have read, Lala Lajpat Rai will die in the protest. Bhagat Singh, actually he stopped that revolutionary activities and he wanted to come to mainstream. But because of Lala Lajpat Rai's death, they killed what was that? Sanders, right? Read in modern India. So there it comes, Simon Commission. Then Simon Commission recommended abolition of diarchy. That was implemented in 1935 Act. Okay. I can't go to that part actually. If I start again, that is a big thing. So that is that you will study that in history. If you read Spectrum, or when the history class will be, they'll take history class, and you will understand that. Okay, just to connect the title. Yeah, then 1947, India, they created 2 dominions, India and Pakistan, and that and India will get freedom on 15th August 1947, and both the dominions will have Governor General, who will be, India asked Mountbatten to continue. Pakistan, it was Muhammad Ali Jinnah, and they the Governor General will be appointed by British Crown on recommendation of Dominion Cabinet. Okay, fine. So next article, that is Union and its territories. Article 1, it says that India, that is Bharat, is Union of States. Article 2 deals with Parliament to add new states which were not a part of Indian Union. Getting my point, right? Example, Goa. Right. Article 3 empowers Parliament to creating new state, changing name of the state, changing the boundary of state, merging of states. All right. So that comes under Article 3. So, but for Article 3 deals with internal readjustment. Right. Article 2 deals with external, adding states which were not a part of Indian Union. You're getting the difference, right? Then Article 4, what it says? The changes made to Constitution under Article 2 and 3 will not come under Article 368. Means it requires what majority? Simple majority. Does not require special majority. Right? Fine. Then what are the three types of majorities we have? Yeah, simple, special, absolute. What is simple? Majority of present and voting, right? What is absolute? Absolute. No. Absolute I'm asking. That is special actually. Majority of total strength. I told you yesterday, 300. 150 is absolute. If there are 150 members are present, then 150 should vote in favor of the bill. Then only it will become absolute. But in simple majority, out of 300, suppose if all 300 are present, then 150 should vote in favor. But if only there are, what happened then? If there are only 150 members are present, then how much? 75 plus. That is simple majority. Majority of present and voting. Right? What is absolute? That is simple. Absolute majority is majority of total strength. Special majority is 2/3 of the members present and voting. Majority of 2/3 of members present and voting. Then that should be greater than half of total strength. Understood? Na? Getting confused with that? Because they'll ask the statement. They'll ask what is this majority, what is this majority kind of thing. Or one statement correct, two statement correct. Or they'll give three majorities here. Simple, absolute, special. Match the following kind of questions. So, got it, no? Simple. You want me to explain once again? Which one? All three? Okay. Yeah. See, there are three, we'll take 300 is the strength of the house. Okay. On that particular day, okay, 50 members are absent. They're not in the session. Okay. For various reasons, they are not in the session. So 250 are present. Okay. If a bill is introduced, which requires simple majority, in that case, how many should support? Half of the 250. That is 125 plus 126. Right? So that is what? Simple majority. Suppose it was a simple bill. I mean ordinary bill. Okay. Suppose a resolution for removal of the speaker is introduced. Okay, I'll come to that while doing central government. I'll explain in detail. That requires absolute majority. So when that resolution is introduced, then absolute majority is required. How many members are present? 250. We don't bother about this. When it is absolute majority, we'll see this number. What is the total strength? 300. So what is the absolute majority required? 150 plus. Correct? No? So out of 250, 150 members has to support or has to vote in favor of the bill. Clear? If there are 300 members, then also 150 has to vote. If there are 250 members present, then also 150 plus has to vote. If there are 150 members only present in the house, then also 150 plus has to vote. That is absolute majority. We don't bother about number of members who are present. We bother about the total strength. If it is simple majority, then number of members present, majority of them. Got it? Simple and absolute. Clear? No? Third one is special. Special, I will take a different number. Okay. It is difficult to divide again. Point will come. So we'll take, say, 150. 150 members are present in the house. Total strength is 300. Okay. So what it says, first condition is 2/3 of members present and voting. Okay, and that should be greater than half of total strength. Clear? Two conditions are there for special majority. First one is 2/3 of the members present and voting. That should be greater than half of total strength. So 150 are present. All 150 supported in favor of the bill. Okay. So 2/3 of 150 is how much? 100. So minimum required is 100, but 150 also, all 150 supported in favor of the bill. So first condition is fulfilled. Correct? No. Second condition, what it says, that should be greater than total strength, half of total strength. How many voted? 150. Half of total strength is how much? 150. Then the bill will be passed. Getting my point, right? Suppose only 140 voted in favor of the bill, 10 members voted against. Getting my point, right? Then first condition is 2/3 of the members present and voting. 2/3 is 100. So first condition is fulfilled. Second is it should be greater than half of total strength. Half of total strength is 150, but here it is only 140. So the bill will not be passed.
So if half of the first one, if half of the first one, 70 members will vote. And 20 members, after the 20 members are against.
No, it is half of the total strength, means half of the 300.
So 170 will vote. 20 will vote against. 20 will be voted. Then the bill is passed.
Yeah. Yeah. Here, if it was simple majority, then there is no problem. We are speaking about special majority. There are two conditions. 2/3 of the members present and voting. That number should be greater than half of the total strength. Half of the total strength.
Either a positive or negative voting should be
Half of the total strength. Okay. So if here, see, I told now 140 members voted in favor of the bill. So first condition is fulfilled. 2/3 of the members voted. But second condition says it should be this one number, whoever supported, that should be greater than half of the total strength. That is not fulfilled. Then bill will not be passed. Clear? Artha aitalva? Done? Okay. Then citizenship, there is nothing much. Article 5 to 11, part 2. Then we started with part 3, right? That is fundamental rights. Article 12 to 35. 36 to 51 is DPSP. I will not be doing DPSP now. After this, I'll start central government. I'll finish central government, state government, then I'll come to DPSP and constitutional bodies. Okay, and emergency provisions, all those things I'll do later. Fine. 12 to 35, part 3. Okay. Article 12, definition of state. Right? You seems lost, man. You're understanding, no? Yeah. Article 12 is definition of state. Right? Article 13. Article 12, yeah. See, it is nothing. Simple. For the sake of fundamental rights, to whom and all, it puts restriction. Or who, it says, I said right to life and personal liberty. Right? For the sake of right to life and personal liberty, your right to life and personal liberty is protected. Against whom? Against state. Right? No. See, if a person is killed or if a person is being threatened, then he cannot claim a fundamental right. If it is from a random person, he cannot claim a fundamental right. That is his legal right. You're getting my point, right? Because there is an independent person is killing another person. Then you can approach a police station. Getting my point, right? Suppose if the state is taking away a person's right to life, then he need not to go to police station. He can directly go to court or high court. See, because his fundamental right is violated.
state is violating this
No, state fundamental right is violated. So what is state there? I said state. No. Who is state? Yeah, that is Article 12 defines who is state. Understood? Now it says that state means central government, means executives, central legislature, then state government, state legislature, then local bodies, urban local bodies, rural local bodies, then all public sector undertakings. Getting my point, right? Then all other authorities which are receiving aid from the state or aid from the government, that will comes under the definition of state. If those bodies violates right to life or any of the fundamental right, the person, the victim, can directly approach the court. You're getting my point, right? So if there is if a person's right to life is violated by an independent another person, then one cannot approach court for seeking like my fundamental right is violated. He can go to court, police station and file a complaint. You got the difference, right? So there it says that what is state? Article define who is state for the sake of fundamental rights. Clear? Understood now? So that is Article 12. Okay, it speaks about definition of state. That's all. Okay. Then Article 13. What is it? Judicial review. What it says? If any act or action of union government or state government or whoever comes under Article 12, na, the state, if any act of them is violating the constitution, if it is violating the fundamental rights, that can be declared null and void by the Supreme Court or by High Court. Article 13 says that judicial review, the judiciary will review the actions of the state, right? So if any act of the parliament or state legislature, if it is violating fundamental rights, that is called as ultra virus. Okay, ultra virus means it violates the constitution. So then the Supreme Court will declare such particular act as unconstitutional. Getting my point, right? That will be declared as unconstitutional because it is violating the fundamental right. Clear? Okay. So they might ask you, what is ultra virus? Ultra virus means the act of parliament or state legislature which is violating the fundamental rights. Okay. Clear? Or constitution. If it is violating the constitution, then Supreme Court or High Court can declare it as null and void. Supreme Court will do it under Article 32. High Court will do it under Article 226. Okay. Supreme Court will do it under Article 32. High Court will do it under Article 226. Okay. Fine. Then Article 14 to 18, right to equality. 19 to 22, right to freedom. 19 is 6 rights. Speech and expression, assembly, association, movement, residence, profession. Right? Article 20, right against conviction for offences. No double jeopardy, no ex post facto law, no self-incrimination. Article 21 is right to life and personal liberty. Right to move within the country is under 19. Abroad 21. Which case it was? Maneka Gandhi case. There they told right to move abroad is a fundamental right under Article 21. Right to privacy is a fundamental right under privacy 21. Okay, there was a UPSC question in 2019 films, I guess. Right to marry a person of your wish comes under which article? 21. Right to life and personal liberty. The right to privacy, right to privacy was declared as a fundamental right under I think Justice Puttaswamy versus Union of India case. It was popularly called as Aadhaar case. Right, when Aadhaar was challenged, now if you remember, taking Aadhaar details was challenged in the court. It was challenged by a person from Karnataka. He was a ex-justice of Supreme Court or High Court, I don't remember exactly. He was a judge. So he challenged it in Supreme Court. In that case, Supreme Court told right to privacy is a fundamental right. Okay. Fine. So next, what I was talking, 21, right to life and personal liberty. 21A, right to education between 6 to 14 years of age. Then 22 is arrest and detention. First thing is grounds of arrest has to be informed. Second is within 24 hours should be presented before the magistrate. Third one is Yeah, legal. He has the right to take a help of legal practitioner, right? Then 23 and 24. 23 and 4. What it deals with? 23 is
Prohibition of employment.
no
Prohibition of personal
traffic of human beings and
human
one more
bondage.
bonded labor. Begar, they call begar. 24 is child labor. Yeah. Prohibition of employment of children in employment of children. Right. Then 25 to 28. That is freedom of religion. Right. Article 25 deals with freedom of conscience, free profession, practice and propagation of religion. Okay. Freedom of conscience, free profession, practice and propagation of religion. Okay. Freedom of conscience means you have the right, freedom of conscience, free profession, practice and propagation of religion. Spelling helbeka? Freedom of conscience, practice, freedom of conscience and free profession, practice and propagation of religion. Freedom of conscience means you can mold your own relationship with God. You can believe in any God, whether idol worship, or if you don't want to do idol worship, that is also nature worship, whatever. You can mold your own relationship with your God. There is no compulsion, or state can put no restriction on it, saying that you should believe in a particular God or you should believe in this particular way of, religious practice. No, there is no such limitation. Okay. Then free profession means you can declare your religious beliefs openly. Right? You can say either you are a Hindu, non-believer, Christian, Muslim, you can say whatever. I mean, you can declare your religious beliefs. Okay. Propagation, you can propagate your religion. Right? But it does not include forced conversion. You cannot convert another person forcefully. Right? But you can propagate your religion. Okay. Then practice, religious practices. You know that, right? In temple we'll do religious practices, homas and different practices are there, and that is your religious freedom. Okay. So it is an individual right. That means it is available to every individual. Right. Then second one is 26, freedom to manage religious affairs. Article 26, freedom to manage religious affairs. 25, right? Freedom of conscience, free profession, practice and propagation of religion. Confused, aita? Understood, right? Freedom of conscience, you can mold your own relationship with your God. Okay. Then propagation, you can propagate your religion. Okay. Practice, you can practice religious practices, you can perform religious practices. Okay. Then freedom to manage religious affairs. It includes purchase and sale of properties. Temples can purchase, build properties. Then they can have their own religious affairs, like religious practices. Right? Like Hindu temples, they can have their own set of religious practices. Islam, they can have their own set of religious practices, like doing namaz or whatever their religious practices are there. Na? So Hinduism, we have different religious practices. Right? You know that, right? There are different pujas, different type of religious practices. So that can be done. And purchase or sale and purchase and maintenance of properties, that all include in the freedom to manage religious affairs. Okay. Then Article 27, freedom from taxation for promotion of a religion. Freedom from taxation for promotion of religion means if you go to any temple, if you do any pujas and all, you will not be paying any tax. Getting my point, right? You will pay fees. If you do a puja, you will take 30 rupees. Now, whatever, some small puja, they'll take 30 rupees. But there is no tax. You're getting my point, right? There is no tax for that. So it is free from taxation. Okay. Freedom from payment of taxation for promotion of a religion. Okay. Then freedom from attending religious instructions in educational institutions. Freedom from attending religious instructions in educational institutions means in education institutions, if there are any religious practices, whether you wish to attend or not, It comes under this fundamental right. There are three things. You just write it down. If the institution is wholly maintained by the state, means completely government school. If the institution is wholly maintained by the state,
It comes under the
27.
27.
Yeah, sorry, 28. Freedom from attending religious institutions. Freedom from attending religious instructions in educational institutions. Freedom from attending religious instructions in educational institutions. Okay.
Freedom from attending.
Freedom from attending religious instructions in educational institutions. In educational institutions. Okay. So A, B, C, D, you just write it down like that. A, if the institution is wholly maintained by the state. If the institution is wholly maintained by the state, then there is no religious instructions. There should not be any religious instructions. Okay. If the institution is wholly maintained by the state, if the institution is wholly maintained by the state, then there are no religious instructions. Okay. Second is, if the institution is administered by state. Institution is administered by state, but if the institution is administered by state but established by a trust, established by any trust. If the institution is wholly maintained by the state, if the institution is wholly maintained by the state but established by any trust, then it is accepted. If the institution is wholly maintained, institution is administered by state but established by any trust, then it is accepted. Religious instructions are accepted. Third one, if the institutions are recognized by state. Institutions are recognized by state, means they are private institutions, but government or state has recognized it. Institutions are recognized by state. It is voluntary basis. It is voluntary basis. Then, if the institutions are receiving aid from the state, if the institutions are receiving aid from the state, it is voluntary basis. If the institutions are receiving aid from the state, receiving aid from the state, it is on voluntary basis. It is on voluntary basis. Understood? Four things. First thing is, if the institutions are wholly maintained by the state, then it is allowed. Right? Sorry, it is not allowed. There are no religious instructions. If the institutions are administered by state but established by a trust, it is allowed. If the institutions are recognized by trust, and if the institutions are receiving aid, if the institutions are recognized by state, and if the institutions are receiving aid from the state, it is on voluntary basis. Okay, means it is the students can decide whether they can participate in the religious instructions or not. Clear? Understood? No? Fine. So next is 29 and 30, cultural and educational rights. 29 and 30, cultural and educational rights. So here one more thing. See, 25, article 25 is there, that deals with individual rights. Correct? No? I told freedom of conscience, free profession, practice and propagation. It all comes for a individual person. Freedom of conscience is your individual right. You can mold your own relationship with your God. Right? That is individual right. Whereas freedom to maintain religious affairs, article 26, that is a community right. It is not for an individual person, it is for a community, for a religion. Clear? No? Fine. Then, cultural and educational rights. Article 29 deals with protecting the language, culture, script of minorities. Okay, protection of interest of minorities, it includes protection of interest of minorities means protection of the language, culture, script of minorities. Okay, here protection article 29, protection of the interest of minorities. Interest of minority means protection of language, culture, script of minorities. Okay, here Supreme Court has repeatedly told that our constitution, in our whole constitution, it says repeatedly minorities, but it does not say who minorities are. Okay, what is the condition to become a minority? It is not mentioned. Supreme Court told that article 19, here minority, not Supreme Court, constitution only for this thing. Minorities means it is not, in minorities there are two things. One is religious minorities, means based on the religion, right? Getting my point, right? Religious minorities. Second one is linguistic minorities. What do you mean by linguistic minorities? Languages, right? In Karnataka, Kannada is the majority language. If you take Tulu, they are linguistic minority. Tamil, Malayalam, all other languages are linguistic minorities. Correct, no? So article 29, protection of the interest of minorities means it is not just religious minorities, it includes linguistic minorities also. Okay, here minority means religious plus linguistic, R plus L. Religious minorities plus linguistic minorities. They might pick your, they have picked this question many times in many exams. Minorities means who? It is just religious or linguistic. It is both. Yeah, for the sake of 29 itself, only for the 29, it is both religious plus linguistic minorities. And Supreme Court in one case told that article 29, that is protection of the language, culture, script, not just minorities, it applies to majorities as well. Okay, everyone's language, culture, script has to be protected. Okay, so next article 30, right of minorities to establish educational institutions. Right of minorities to establish educational institutions. Article 30. Here it is applicable only to minorities, not to majorities. Article 29, Supreme Court told that it applies to majorities as well. That is protection of the language, culture, script. It applies to majority as well. Article 30, right of minorities to establish educational institutions. Here also minority means religious plus linguistic, but article 29 applies to majority as well, but article 30 is applicable only to minorities, both religious plus linguistic. Okay, interest of minorities, where interest means protection of the language, culture, script. Yeah, constitution, Supreme Court in many judgment is said that it is not just minorities, it is applicable to majority as well. You should protect the language, culture, script of majority as well, Supreme Court. Okay, but 30 is applicable only to minorities.
Then why are they minorities?
Yeah, constitution, because there is no definition who minorities are, it is not mentioned. That is the ambiguity. Our constitution, no, that is the ambiguity. That is why every case will go to court. One to five, no? I'll come to that. We'll discuss. Yeah, we'll come to that. That was a homework, right? Yeah, I'll finish this and I'll come. Okay, so article 30 is what? Protection of the, right to minorities to establish educational institutions. What was your degree? Like you? BBU? BTech, you? BCom. When you were applying for examination like CET or whatever university, there will be some institutions which were called as minority institutions. Right? Minority institutions. They will be established under this act, this article. All right. In that, those minority institutions, some percentage state. Yeah, Muslims. There are in India. There are, except Hindus, all other minorities. Right. We have Jains. They were earlier they were called as majority. I mean, they were called as part of Hindu religion only. Now I think in I don't remember when exactly, 2014 or somewhere, they are called as sixth minority. They called Jains as minority. So now even Jains can establish education institutions under minority clause. There will be some institutions, they are established on both religious and linguistic. In Karnataka also, there are many Tamil institutions are there. They are called as linguistic minority institutions. In coastal, if you go to coast, Mangalore, Udupi and all, the institutions, if they are established under Tulu language, minority status, they are called as minority. If the kid, like my sister and all, my mother tongue is Tulu, but in my TC and all, it is Kannada, written Kannada. My cousin and all, they have given Tulu as their mother tongue. So they can take a mother tongue certificate as Tulu and they can apply to those education institutions. Getting my point, right? If they establish minority education institutions, there will be some seats reserved for those sections. If it is a Muslim minority education institutions, some percentage of the seats, I think in Karnataka, the percentage varies from states to states. I think in Karnataka it is 50%. 50% of the seats will be reserved for that community, either linguistic or religious. If it is religious, for that religion. If it is linguistic, for that linguistic community. You got my point, right? So it is the right of minorities to establish educational institutions. Okay, they have a constitutional right to establish educational institutions. Okay, any doubts? It is simple. Okay, fine. So next one is Article 31. What is Article 31? It was right to property. So it was amended, it was abolished by which Constitutional Amendment Act? No, now it is a constitutional right under Article 300A. So it was abolished under which Amendment Act? Abolished by which Amendment Act? Which amendment? Constitutional amendment. Sorry? Yesterday I told, right to property was abolished. No, 44th Constitutional Amendment Act of 1978. Okay. So, right to property was a fundamental right under Article 31 that was abolished by 44th Amendment Act of 1978. They have asked many times, like not exactly this, but related to amendments in your exam, IB exam. Okay, that is why I'm stressing. 44th Amendment Act of 1978, right to property was abolished. Okay, and they made as a legal right under Article 300A. Okay, there is no more a fundamental right. What is the difference? If, yeah, he cannot go to court. If his right to property is violated, he can go to police station. That's it. It is a legal protection, not a constitutional protection. Clear? Fine. Next is C. Constitutional remedies. Article 32. Till now, we were speaking about rights. Correct, Allah? So you have many rights, but there is no mechanism to get those rights. Then what is the point of having a right? See, government has said that we will give you every month some 10,000 rupees to each person, right? But there are no banks, there are no setup to get those 10,000 rupees. What is the point of just saying that we will give you? There has to be some mechanism to get that. So it is like constitutional remedies are like, it is a way to get your rights if they are violated. Getting my point, right? So the Constitution has provided a mechanism to protect your rights through Article 32. And protecting your fundamental rights itself is a fundamental right. Getting my point, right? Protecting your fundamental right itself is a fundamental right. There is no point of violating Article 32. You can approach a court. See, you will use Article 32. That is what I'll come to that. Okay. So, under Article 32, there is something called writs. Okay. Writs. One can file writs in court of law, means in either in Supreme Court or High Court, if your fundamental rights are being violated. Okay. So, there are different types of writs. First one is habeas corpus. Habeas corpus. Habeas corpus. Habeas corpus. Okay. Habeas corpus means to have the body of. It is a Latin word. In meaning is to have the body of. Means if a person is, you must have heard, na, like this habeas corpus, it will come repeatedly come in newspaper. Habeas corpus, right? So if a person is illegally arrested, if a person is illegally captured by anyone, then his fundamental right is being violated, right? Then that person, someone from his relative or anyone, can directly approach the court of law and file a habeas corpus. Then it is the duty of the state, means police, to produce that person before the court. Getting my point, right? I was talking about Article 22. What it says? A person has to be presented before magistrate within 24 hours. If he is not presented, then one can go to court and file a habeas corpus. Getting my point, right? Then the police has to produce him before the court. Understood, na? That is habeas corpus. To have the body of. If a person is illegally captured, then if the habeas corpus is filed, it shall be the duty of the state to produce him before the court. Then court will check whether it is legal or illegal. If it is illegal, then court will leave him free. Got it, na? Artha aitalva? See, there was a case, like, I don't know whether I can tell this or not. There was a case in Kerala. I don't know whether you guys followed it or not. There was a girl called Hadia. She went and she married a boy. So her dad filed a habeas corpus in Supreme Court. Because I don't know where my daughter is. Then Supreme Court gave directions to the Kerala police. Then Kerala police found her and presented before the Supreme Court. She was a major. Then she told, I'm married voluntarily. Then court, left her.
Sir, is this missing case?
It was not missing case also that can be filed, but there has to be like the police, there has to be some reason. Simply for missing case and all, no one will go and file a habeas corpus. You have given a complaint, police is not taking any action, then someone can file a habeas corpus. Straight away you can't file a habeas corpus. You got my point, right? Straight away one cannot file a habeas corpus. Okay. So you got it, no? If someone is illegally captured, then one can file a habeas corpus. Okay. So next one is mandamus. Mandamus. So habeas corpus can be filed against state as well as private person. Okay. Private person melu it can be filed, not just police or any state authorities. It can be filed against a private person as well. That they might twist the words and ask the questions. Okay, be clear about that. Habeas corpus can be filed against private person as well as state. Okay, fine. So mandamus means it is issued by a court if a government authority has failed to perform the duty. Okay. If the government, you want exact words, it is issued when public official fail to perform his duties. Mandamus is issued when public official fail to perform his duties. Public official fail to perform his duties. See example. Yeah, you have given some application for some job or whatever, some work, but it is legal, but that official is not doing it. Then you can file a mandamus, asking him to perform his duty. Okay, that is mandamus. Okay, and here one more thing is, mandamus can be applied or filed against only public official, not against private official. Got the point, right? Habeas corpus can be filed against public as well as private, but mandamus can be filed only against public official, not against private official. That is the difference. Okay. Then prohibition. Third one is these two things you got it now. Habeas corpus and mandamus. Prohibition. Yes, you can. You have applied for some government job, like your documentation or whatever, property related, whatever. If they are not doing your job, you can directly file a mandamus. Okay, but na, Indian judiciary, the process and all. So prohibition is, it is filed to prevent a lower court from exceeding its jurisdiction. It is filed against a lower court to prevent the lower court to exceed its jurisdiction. Okay, it means to forbid. There is again Latin word, issued by a higher court to lower court or tribunal to prevent later from exceeding its jurisdiction. It is issued by a higher court to a lower court. Higher court means either Supreme Court or High Court. Higher court to lower court to prevent lower court to exceed its jurisdiction. Okay, exceed its jurisdiction. I can't tell you the exact words whatever I have written there. So okay, prevent lower court from exceeding its jurisdiction. What happens, there are cases when lower courts, for various reasons, they may exceed their jurisdiction, they may pass orders. Getting my point? In such case, one can approach the Supreme Court or High Court asking the lower court to stop giving such orders. Okay, even though the court does not have the jurisdiction, they might give some orders, right, to prevent that against court as well as tribunal. Recently, in Karnataka Administrative Tribunal, KAT, there is called administrative tribunals. Okay, CAT, have you heard about it? Central Administrative Tribunal. Similar to that, there is KAT, Karnataka Administrative Tribunal. They will take care of administrative matters. Okay, so there was in Karnataka, the reservation is increased to 50% to 56%. Okay, that was challenged in KAT. So they gave a judgment, they scrapped it. They said that it is violating Indira Sani judgment of 1992. There is a case called Mandal case or Indira Sani case. So in that case, Supreme Court told that the reservation in India should not breach 50%. 50% is the cap. Remaining 50% should be open to all. Okay, in that judgment, that is famously, you must have heard, no, Indira Sani case, 1992. It is also called as Mandal case. So that was the judgment. So based on that judgment, CAT told it is violation of the Supreme Court judgment, so they squashed it. So now Government of Karnataka has filed prohibition in High Court, asking to squash the judgment of the KAT, Karnataka Administrative Tribunal. Like that, the lower court or tribunal exceeding its jurisdiction, one can file the prohibition. Okay. Next one is certiorari. How you pronounce it? Some will pronounce certiorari, something. Certiorari. Certiorari. Okay. To be certified or to be informed. Okay. To be certified or to be informed. It is issued by a higher court to a lower court or tribunal, either to transfer a case pending before the lower court or to squash the judgment of the lower court. It is issued by a higher court to lower court, either to transfer the case pending before the lower court or to squash the judgment of the lower court. Okay. It is issued by the higher court to lower court, either to transfer the case pending before the lower court or to squash the judgment of the lower court. Okay. It is issued by a higher court to a lower court, either to transfer the case pending before the lower court or to squash the judgment of the lower court. Same prohibition, certiorari, both the duty is same, but one difference is it is both. There it is just stopping the lower court to exceeding its jurisdiction. Here the court can ask the lower court to transfer the case pending before the lower court. It is preventive as well as curative, because here one is transferring, second one is squashing. Both is there. So certiorari is both preventive as well as curative. Okay, preventive as well as curative. Last one is quo warranto. Quo warranto. Quo warranto. To check the legality of usurpation of public office by a person. To check the legality of usurpation of a public office by a person. To check the legality of claim of a person to a public office. See, example, if the government has appointed someone as a Lokayukta, okay, but you feel like he is not eligible to that position. He has some shortcomings in his qualification, or there are some allegations or whatever kind of thing. Then you can directly go to Supreme Court asking by filing quo warranto, saying that that person is not qualified enough to be appointed to that position. Anyone can file a quo warranto. You need not to be you need not to be a person who is affected by the decision. Anyone can go and file a quo warranto. Understood what quo warranto is, right? If a person is holding a public office, to check the legality of that position, whether he is eligible for that or not. That is quo warranto. Right? What are the different writs we have? Habeas corpus, mandamus, prohibition, certiorari, quo warranto. Habeas corpus, if a person is illegally captured, then to release him. Second one is mandamus. If the government official is not doing his duty, then we can file it. Prohibition, yeah, higher court to lower court, to stop the lower court from exceeding its jurisdiction. Certiorari, yeah, to shift the case pending before the lower court or squash the judgment of the lower court. Then quo warranto, to check the legality of claim of a person to a public office. Clear? Fine. So, ಅರ್ಥ ಆಯ್ತಲ್ವಾ? ಫಾಸ್ಟ್ ಅನ್ನಿಸ್ತಿದ್ಯಾ? Understandable? Right. So, I told Article 32, that is the right to protect the fundamental rights. So, under Article 32, it is the Supreme Court that can issue writs. Correct? No? Then there is another provision, Article 226, which allows High Court to issue writs. Okay, our constitution empowers, okay, our constitution empowers parliament to allow any other court to issue writs. Okay, parliament has to pass a bill, resolution, and allow that particular court to issue writs. But till now there is no such resolution has passed. So current position is only Supreme Court and High Court can issue writs. Supreme Court can issue writs under Article 32. High Court can issue writs under Article 226. One difference is Article 32 is a fundamental right, whereas 226 is not a fundamental right. Got the difference, right? Both Supreme Court and High Court can issue writs. Supreme Court under 32, High Court under 226. 32 itself is a fundamental right, but 226 is not a fundamental right. So the difference is you can approach either High Court or you can approach Supreme Court if your fundamental rights are violated. Clear, na? But High Court can refuse to issue a writ, whereas Supreme Court cannot, because this itself is a fundamental right. You asked no that time. This itself is a fundamental right. So Supreme Court cannot refuse to issue a writ, but High Court can refuse to issue a writ, because 226 is not a fundamental right.
But it has a
Yeah, they can issue writs, but compulsory to for them to issue writs. They can refuse to issue a writ because it is not a fundamental right. Article 32 itself is a fundamental right. If you go to Supreme Court for filing a habeas corpus, Supreme Court must take that case because it is a fundamental right, whereas High Court need not to. It can refuse because it is not a fundamental right. Second thing is, Supreme Court, it is a fundamental right. So Supreme Court can issue writs only for the sake of fundamental rights, whereas High Court can issue writs not only for the implementation of fundamental rights, for other functions also, because it is not a fundamental right. Got the difference, no? Right? First thing is Article 32 itself is a fundamental right. Article 226, which allows High Court to issue writs, is not a fundamental right. Right? So the aggrieved person or the person affected by or whose fundamental rights are violated, he can directly approach the Supreme Court or he can go to High Court. If he go to High Court, then High Court can refuse to issue a writ. Whereas if he go to Supreme Court cannot refuse to issue a writ, because 32 itself is a fundamental right. Clear? Second thing is under Article 32, the Supreme Court can issue writs for the protection of fundamental rights only, whereas High Court can issue writs for other legal matters as well, not just for fundamental rights, because Article 226 is not limited to fundamental rights. Clear? So in that case, Article 226 has wider scope, whereas 32 is limited to fundamental rights. Got it? No? They will ask statements like that only. High Court can issue it for legal other than fundamental rights. Supreme Court can issue it only for fundamental rights. High Court scope is wider. Okay, but High Court can refuse because it is not a fundamental right. Clear? Okay, fine. So next, yeah, 32 is done, right? Yeah, Dr. Ambedkar called Article 32 is the heart and soul of the Constitution. Okay. Heart and soul of the Constitution. Ambedkar called it. If you are preparing for mains, UPSC or KS, then these statements are very much important. If there are anything asked related to fundamental rights or whatever, you can start with that quote. In introduction, you just write it. Dr. B.R. Ambedkar called Article 32 as the heart and soul of the Constitution. You can continue with your answer. Right? Fine. Next, we are done with 32, na? Okay. Article 33. Article 33. What it says is, any idea? It is the limitation on, you want to write it? Okay. So it allows the parliament to restrict fundamental rights of the members of armed forces, police forces, paramilitary forces, intelligence agencies. Article 32 allows Parliament to restrict fundamental rights of the members of armed forces, police, paramilitary, intelligence agencies. Fundamental rights of the members of armed forces, police, paramilitary, and intelligence agencies. Armed forces, police, paramilitary, and intelligence agencies. Yesterday I was telling, right to form association. Under Article 19, there is a right to form association. But have you ever seen there is an association of police or military association? No. Because there is a discipline, right? And whose phone is? Okay. So because if you allow them to form associations and groups, then it will affect the unity among the paramilitary, police forces, armed forces. So that is, it will affect the whole national security. So Parliament can put reasonable restrictions on application of fundamental rights to police forces, armed forces. Article 33 empowers Parliament to put reasonable restrictions on application of fundamental rights on armed forces, police forces, intelligence agencies. Okay, they can put restrictions. Okay, you know there are rules like the army personnel or police, they cannot write articles, papers, they cannot speak against the state. Getting my point, right? Because you can't say that speech and expression. No, there is something called Official Secrets Act. That is what Article 33 deals with. It allows government to put restrictions. You have that right, but we can't provide that right to persons who are in army. They'll get it after their retirement. That is why there is Official Secrets Act. Right? They can't say that I'm just speaking because I have speech and expression. They can't say that. No, because it affects larger interest of the country. If a person in border, if he is writing in newspaper about all the army details, it is affecting the whole nation, right? So that is why our constitution framers provided this provision which empowers parliament to put restrictions. You got my point, right? So there is a restriction. Okay, so only parliament can make such laws which restricts the application of fundamental rights. Clear? Then Article 34, which deals with application of fundamental rights during martial law. During martial law, application of fundamental rights during martial law. What is martial law? It is not mentioned in the constitution. Martial law means it is military rule. Okay, but nowhere in constitution it is the provision related to martial law is not being mentioned. Okay, martial law means military rule. Only in Article 34 it says that it deals with restrictions of fundamental rights during martial law is in force. Okay, but what is martial law? When martial law can be imposed? It is not being mentioned in anywhere in constitution. Okay, they have just given the word martial law, and till now it is not being applied in India, implemented in India, right? So we don't know what exactly martial law is. Okay, so martial law means
During the emergency.
emergency is not military rule. That is national emergency. Article 352, 356, 360, national, state and financial emergency. That is different. Martial law is different. Emergency. Huh? Yeah, 350, 352, 356. There is no armed rebellion will not come under 356. That comes under 352 national emergency. No. Martial law is different. That is different. See what emergency says. When armed rebellion is there in the country, then national emergency can be imposed. So there are different provisions. Again, there 358, 359 that deals with what happens in the country, what happens to fundamental rights when national emergency is imposed. That is 358 and 359. I'll do it while I'm doing national emergency and president rule and all. But that is different. But martial law, this martial law word you will see in our constitution only in Article 34. That's it. Nowhere it is not being mentioned. Okay, clear? Article 34. That's all. Okay. Then Article 35. Article 35. It says that only Parliament can make laws for the implementation of fundamental rights. Only Parliament can make laws for the implementation of fundamental rights. Why? Only Parliament can make laws for the implementation of fundamental rights. Yeah, very good. Because there has to be uniformity throughout the country. Right? If you empower state governments to make laws, then how can Supreme Court implement them? Getting my point, right? See, we say abolition of untouchability. Untouchability is abolished. Then there has to be a law, na? Article 20, abolition of untouchability 17. Article 17 says abolition of untouchability. So, okay, Constitution said that untouchability is abolished. Then there has to be an act to give punishment, na? Those who are practicing untouchability. Then Parliament has to bring a law. Right? If you allow state governments to bring a law, then Karnataka will give 10 years punishment. Andhra Pradesh will give 15 years. Tamil Nadu will give 20 years. So there is no uniformity, right? So Article 35 says it is only the Parliament that can pass a law to implement fundamental rights. Understood? To implement fundamental rights, it is only Parliament has the right to implement a law, to make a law or to pass a law. Clear? That is Article 35. Okay, that is about fundamental rights. Article 12 to 35. Artha aitalva? Clear? Fast anisthidya? Right, fine. So Article 12 to 35. Okay, there are limitations of fundamental rights, criticisms and all there. That is for your IB exams, that is not required. But if you are preparing for mains and all, go through it, because that is required for answer writing. Okay, for prelims perspective, that is not needed. Okay, but when you are reading, just go through it once. Okay, what are the limitations of fundamental rights and all? Okay, so DPSP I'll do it later. I'll start with central government now. Okay, Article 52 to 78. Okay, so Article 52 to 78 is, sorry, Union Executive. Okay, 79 to 122 is, oh no, Parliament. 123 is ordinance making power of President. 124 to 147 is Supreme Court. We will be doing all these things, part from Union Executive to Supreme Court. Okay. Ordinance making power of President. What is that? I will explain to you. Okay. Part 5 of the Constitution. Part 4 is DPSP. Okay. This is part 5 of the Constitution. Yeah. 148 is CAG. Comptroller and Auditor General of India. I'll do that in constitutional bodies. Okay. Here in between again Article 76 will come. That is Attorney General of India. Okay. So part 5 of the Constitution. Article 52 to 78. Initial will start here. I'll not be doing every single article. Okay. I'll teach what is President, Vice President, all details. Article you must go through because there is nothing to teach. You should remember the articles. Okay. Like 76, 123, 110, 112. Important articles I will be speaking. Okay. But every single articles like article deals with election of President, Vice President, that you will have to check it. Okay. It is given in Lakshmikant last page. They have given articles. All single in every after every chapter they have given 10 to 15 articles. You see the see here they have given articles. All in after every chapter they have given articles. You have to go through it. Okay. But you can't remember all the articles. Remember this logic. Okay. It is very difficult to remember. There are more than, you will have to remember almost on 150 to 200 articles. What you have to do is, have set up a study table. Na? You have set up a study table, right, in your home. A place to study. Right. There you put a stick of paper with all important articles. Every day you have to see it. Right. That you should do because it is very difficult to remember all the articles. We'll keep on forgetting it. Okay, fine. So first we'll start with central government article, that is executive. Okay, Union Executive consists of any idea who all are part of Union Executive? Union Executive, yeah, President, Vice President, PM, Council of Ministers. Council of Ministers include cabinet is within Council of Ministers. So take this is a Council of Ministers. In that there will be cabinet ministers. Then there are Minister of State. Then there are Minister of State with independent charge. Right. So that is the total Council of Ministers includes all three. Cabinet ministers. The important ministers are called cabinet ministers. Right. Then there are Minister of State to help the cabinet minister. Then there are Minister of State with independent charge. They will be having their independent ministries, but they are Minister of State. Okay. So here it includes. That is why we use the term Council of Ministers. Then who? One more person. Union Executive includes President, Vice President, Prime Minister, Council of Ministers, and Attorney General. Okay. Attorney General of India. He is a part of Union Executive. They might ask this question. Okay, who all are part of Union Executive? It is President, Vice President, Prime Minister, Council of Ministers, then Attorney General. Who is the Attorney General now? Any idea? I think Subramani. Check it. Google it. Okay. I think Subramani. Sorry? Council of Ministers, yeah, he can be a member of Lok Sabha or he can be a member of Rajya Sabha. Okay, you're asking that only, no?
What about
There is a limitation. See, yeah, that is what I told. A minister can be a part of, either he can be a Lok Sabha member or he can be a Rajya Sabha member. Manmohan Singh was the Prime Minister, na? He was not a Lok Sabha member. He was a Rajya Sabha member from Assam. Devegoda, the Prime Minister. Yeah, Jai Shankar is a Rajya Sabha member. Yeah, Jai Shankar, very good. And Nirmala Sitharaman from Karnataka only, na? She got elected to Rajya Sabha from Karnataka, right? So they can be a member of either Lok Sabha or Rajya Sabha, right? Fine. And I think Devegoda, Manmohan Singh, I.K. Gujral was also from Rajya Sabha, I guess. Was doing, yeah. Attorney General. This part you got, no? These four are the part of Union Executive. Okay. So first person is President. Okay, we'll start from there. See, recently there are multiple controversies regarding Vice President. So President and Vice President, this part you'll have to read properly. You might get one question. Okay. So President. I'll give a break after doing this, or will you take now only? It's 3:30. Want break? If you want, you can take 5 minutes. Yeah.
how many residents are there now?
Huh.
Who is the president?
Oh, sorry, come again.
How many residents are there now? 17, 19,
Ah,
and now who is the president and who is the president?
that is not required. They will not ask.
But I thought, who is the current something?
Current Advocate General, Attorney General, they will ask. Yeah, that and all you will have to go through. But the previous list and all not needed, man.
I was asking 17 president. Like that.
Yeah, that number, that I don't know exactly. Numbers and all I don't know. Check it, because for UPSC and all they'll never ask these kind of things like who is the current president, who is the current CJ and all. They will never ask.
Number 17.
Okay, who is the what is the term they'll ask. Huh? Just check it exact number, you check it. I don't know exactly, like 18th who is the 18th president, who is the 17th president, 16th president, like that.
At present, what is the
Okay, at president, prime minister number. Okay.
17th prime minister? Like that.
Okay, I don't know exactly the Modi, I don't know exactly. We'll check it. We'll check those facts. Just we'll check it. Okay, then take a 5 minutes break. We'll start president after that. Mute it. No? President. Okay. Till now you understood, na? There's no confusion, right? Yeah. Who is the current president? Draupadi Murmu. Who was the first president? Who was the first president? Yeah, good. Dr. Babu Rajendra Prasad. Who was the first vice president? We celebrate Teachers' Day, na? Sarvapalli Radhakrishnan. He was the first vice president. Second president was also Babu Rajendra Prasad. Second vice president was also Radhakrishnan. Third president is Radhakrishnan. Right? Is anyone from Karnataka became president? He was not from Karnataka. He was working in Mysore University. As a professor, he was working in Mysore University, but he was not from Karnataka. I think he was from Andhra Pradesh. Sarvapalli Radhakrishnan is from Andhra Pradesh, not Tamil Nadu. I think Tamil Nadu. Tamil Nadu. Thank you. Who is another one?
Abdul Kalam was level
11th?
Abdul Kalam.
Thank you. Okay. There is one person from Karnataka who became vice president, B.D. Jatti. Basappa Danappa Jatti. He was a vice president. Okay. Fine. We'll start with president. First one is election of president. Who will elect president?
Electoral college of the both the houses. Lok Sabha and Rajya Sabha.
That's all. So, president will be elected by a electoral college consisting of elected members of Lok Sabha plus Rajya Sabha. Why I am stressing elected is in Rajya Sabha there will be 12 nominated members. Right? Recently Sudha Murthy and recently some other got nominated, na? Kamal Hassan was elected, I guess. He was elected. Nominated famous personalities who got nominated recently. This some foreign secretary, ex-foreign secretary, and Ujjwal Nikam from Maharashtra. He got nominated, and two more got nominated. P.T. Usha earlier, she got nominated. Sudha Murthy from Karnataka, sorry. Ilayaraja also, no? He got nominated, no? Yeah, Ilayaraja. Like that, there are 12 nominated members in Rajya Sabha. So that is why I am stressing elected. Only elected members will participate in the election of the president. Then elected members of state legislative assemblies. Elected members of state legislative assemblies. Only from assemblies, not from council. Okay? Elected members of state legislative assemblies. Then elected members of assemblies of union territories of Delhi and Puducherry. Okay? Elected members of assemblies of union territories of Delhi and Puducherry. Okay? Clear? It consists of electoral college consists of elected members of Lok Sabha and Rajya Sabha. Okay? Then elected members of state legislative assemblies. Then elected members of legislative assemblies of union territories of Delhi and Puducherry. Okay? Clear? So that is the electoral college. They will elect the president. Okay? Clear is it? Then it is not like there is something called value of vote of one MLA and one MP, right? So first, because it is based on the population, right? So value of vote of one MLA is equal to one MLA is equal to total population of the state divided by total number of MLAs into 1 by 1000 of state. If Karnataka, if we take, well, the recent data available is 2011 census, right? It says I think 6 crores some number is there, population. Let's take 6 crores. 6 crores is the population. 6 crores, no? 6 crores is the population. Total number of MLAs from Karnataka is how much? Any idea? 224 into 1 by 1000. Calculate it. This is the value of vote of 1 MLA. Okay? 6 lakh, no? 60,000 by 224. Okay? This is the value of vote of 1 MLA from Karnataka into 1 by 1000. That is to reduce the value. It becomes very huge number, na? To reduce 1 by 1000. Okay? Then this is the value of vote of 1 MLA. Okay? Then value of vote of 1 MP. If MP is equal to value of vote of all MLAs divided by total number of MPs. It includes value of vote of all MLAs divided by total number of MPs. It includes both Lok Sabha plus Rajya Sabha elected. In Lok Sabha it is 543 plus Rajya Sabha 245 12 233, right? 543 are elected plus 233. Totally current strength is, total strength is 250, right? Rajya Sabha's total strength is 250. Current strength is 245. Out of 245, 12 are nominated members. So 233 are elected members. In Lok Sabha, total strength is 552. Current is 545. 2 are nominated members. So 543 is number. 543 plus 233. Okay. Value of vote of 1 MP. Okay. Value of vote of whole India. Yeah, all states. Then 2 union territories, including the value, you will get some number, na? Dividing that with total number of members of Lok Sabha and Rajya Sabha. You will get some value. I don't know exact, it varies from election to election. Okay, because population changes, na? But currently we have, it is again, whatever the data is in 2011 census, na? Based on that census. Recent official data, right? Now when I wrote KS mains, na, we are in 2025. Because the last, I think next year they'll do population census. We have 2011 data. Whenever we are writing answers, we will mention 2011 data only. Because we don't have any official information, na? Because that is the official data available, right? Fine. I'll come to that. He is elected by means of proportional representation. I'll explain it.
This process or that is different?
I'll explain. I don't know how much you will understand. That is not required for examination, but I'll explain it. Okay. See, there is something called proportional representation. See, you all have election voter ID, na?
So only this one is done, sir, President.
For election is done, but other part is there. His roles, responsibilities, how to remove him, what are the qualification is there. I'll come to that. She asked about election proportional representation. Na? President is elected by means of proportional representation. See, what ID you don't have? How old are you?
23.
Why haven't you taken? This is your responsibility, man. You should apply it. Apply it online. You can apply it online. You both have, no? Vote madidira? Yeah. So you both have voted. Now see, when you are only which election you have voted? MLA? MP, MLA. Yeah. You will just go. You will press that button. Done. Right. That is a normal. First past the post. That is a normal election. Means if there are 10 people who voted, the one who has got highest, if there are 20 candidates, one person got 2 votes, remaining all got one vote, then the person who has got 2 is elected. Right?
First past the post will come in the prime,
Yeah,
prime minister.
same. In proportional representation, what happens is, number of person to be elected divided by, okay, number of person to be elected divided by 1 plus 1 plus 1. Sorry, one second. It is not number of person to be elected. It is total value of votes. Total number of votes. Total number of votes. Okay. Total number of votes. Here I'll write not 1 plus 1. I'll write the formula. Number of person to be elected plus 1, numerator plus 1. Total number of votes, number of person to be elected plus 1, numerator plus 1. Okay. In president election, number of vote say some x. X is the number of votes. Number of person to be elected is how much? How many president you need? 1 plus 1, numerator plus 1. It will be x by 2 plus 1. I'll take a random value, say 1500 votes. Okay. Try to understand it. Exam, it is not at all required. In your Lakshmikant, it is given. Okay, but if you read it now, you will not understand it. You will not understand it. Yeah, it is little complicated. Huh? So, I'll say 1500 votes. Okay, 1500 is the vote. How many person? 1 plus 1, 2 na? 1 person to be elected plus 1 plus 1. So it is 750, right? Plus 1. A person need to get 751 votes to select as a president. 751 votes he should get. He should get 751 votes. Then only he'll be elected as a president. Right? So what happens here is, while giving the ballot paper, okay, it is not like where MP election, you will go and you will press a button, one vote is done. It is not like that. You will have to give preferences. Okay, if there are 3 candidates, you will give first preference, second preference and third preference. Got it? First preference, second preference and third preference for 3 candidates. In first round, what they will do is, they will count all the first preferences. Okay, there are 1500 voters have voted. Okay, so there are 3 candidates, A, B, C. Out of first preference, first candidate has got 1000 votes, second some 300, third 200. First preference. But how much we need? 750. So first one got 1000. He is elected as a president. Done. Then they will not go for second preference. Suppose this is the one case. Okay. Suppose the first person has got say 600, 500, 400. Correct? Here, how much we need? 751. No one has got 751. So no one is elected as president. Here what they will do is, the person who has got the least, he will be eliminated. Okay, and they will take his 400 votes, and who has got the second preference na? Those 400 people, they have given first preference to C, right? And they have given second preference to some other person out of them. And third, out of A and B, they have given second preference to one person, third preference to one person. They will transfer those second preference votes to them. If out of 400, 300 has given second preference vote to A, then 300 will be added to here. 100 will has given 100 people has given second preference to B. 100 will be transferred to here. Clear? Now the number of votes 900 is A, B is 600. So A is selected as president. Suppose here also, if 751 is not met, then again the least is B. His second preference, out of this 500, people have given second preference, na? That will be transferred to A.
But what if the 400 persons will also be option is first option will be B, then
That is what I'm saying, na? This ulta you are saying, na? Yeah. In that case, here it is 100, na? Here it is 300. Then he has passed, no? If not, then his second preference vote will be there, no? They will open the ballot paper again. They will see who is the second preference there, and that vote will be shifted. Like that, they will keep on doing it. If there are 10-15 candidates, they will eliminate from the 15th one. Like that, they'll come to first candidate. That is proportional representation. Understood? So it again, if there are in ML elections in Gram Panchayat, if you have gone, you will have to elect 2-3 candidates. In such case, this formula will change. There are 1500 voters. You need to select 2 candidates. Then 2 plus 1 plus 1. Then 1500 plus 3 plus 1. It is 501. 2 people has to score 501, 501. Then there will be 2 persons will be elected. Like that it varies. Depends on number of person to be elected. Clear?
First past the post will decide.
Yeah. It is called first past the post. Yeah, proportional representation, that is a formula. So yeah, the first one who passed this number, he will be elected as president.
what is the call in prime minister election?
Prime minister election, there is nothing called like that. Prime minister is selected from the majority party. They will choose their leader of their leader. He will become the prime minister, right? But in MLA election, it is not like that. You will just vote. Who has got the highest numbers, he will be elected. Even if 3 voters cast their votes, the one who has got 2 will be MLA, right? Understood, na? Fine. So next, qualification of the president. Qualification. What is the age? Minimum age to become a president of India? 35 years. 35 years is the minimum age. Okay? Yeah, he should be Indian. Should have completed 35 years of minimum age, and he should not be holding any office of profit. Okay? Should not be holding any office of profit. And if he is a member of either house of the parliament or state legislature, he will have to resign before entering into the office of president. Okay? Simple. Here important is minimum age, 35 years of age. Then he should not hold, he should not have held any office, he should not hold any office of profit. And third one, if he is a member of any house of the parliament or state legislature, he should resign before entering into the office of president. Okay? Office of profit means, see, if he is a member of any boards, state government boards, or if he is a part of any PSUs, where he is drawing salaries. Simultaneously, you can't do both the jobs. Okay? So that is called...
Is it mandatory that he should be an MP before, sir?
No. It is not mandatory. If he is a MP, then he should resign before entering into the office of president. MP can become a president while he can contest for elections. If he got elected, before taking oath, he should resign to the member of MP.
We are written like qualified to be.
Yeah. I was about to tell you that. So when he is a member of, to become a president, he should have qualification to contest for the election of MP, member of Lok Sabha. To become president, he should have qualification to become the member of Rajya Sabha. Qualification. He need not to be a MP or need not to be member of Rajya Sabha. He should have qualifications. Okay, that's all. There is nothing like he should be a part of Lok Sabha or Rajya Sabha. If he is a MP, then before taking oath, he should resign to the Lok Sabha, and or if he is a Rajya Sabha member or state legislature, he should resign. I think Ramanath Kovind, when he became when he got elected to president, he was a member of Bihar cabinet, I guess. He was an MLA in Bihar Legislative Assembly. He resigned and he became president. Okay, I think Draupadi Murmu also, she was a minister in Odisha cabinet, I guess. Yeah, she was a minister. She resigned and became president. Okay, fine. And yeah, this you understood, no? Then who will prescribe oath to president? Chief Justice of India. Okay, that is Chief Justice of Supreme Court. CJ will prescribe oath or affirmation to president. In his absence, the senior most judge of the Supreme Court. Okay, it is the CJI, Chief Justice of India. Who is the CJI now? Gawai, Justice Gawai. I think after Gawai, Justice Nagratna will be the CJI. She is the first woman CJI of India. She is from Karnataka. She will be the first woman CJI of India. So she will be the first woman CJI.
What is the affirmation?
Same, oath or affirmation, both are same. Okay, so it is the CJI who will prescribe oath or affirmation to president. In his absence, senior most judge of the Supreme Court. Who is the next senior most judge will be there, na? He will be giving oath to president. Okay, fine. Next is removal. A term, yeah, term you know, na? Senior most judge of Supreme Court. Senior most in the sense, it is not just by means of age. The day when they entered, when they become a judge of the Supreme Court, na, from there their seniority counts. Okay, if they are 10 years, if they have served as a Supreme Court judge, if there are another judge who has served as 9 years, then the one who has served 10 years will be the senior most. Because there is no minimum age to become a judge of the Supreme Court. So age varies. Okay, fine. So term is 5 years, right? Term of the President of India is 5 years. Okay, then resignation. To whom he will give resignation? Vice President. President will give resignation to Vice President. Okay. Huh?
For whom she can do, sir? And the Vice President is also not.
Yeah, Vice President is not there, and at such time it is the Chief Justice of India.
She can do
Chief Justice of India, if she wants to resign. Because the Constitution says, when President office is vacant, then if Vice President office is also vacant, then Chief Justice of India, if vacant in the sense, if the President died and there is no Vice President, he also resigned. In such case, the Chief Justice of India will act as an acting President. In his absence, the senior most judge of the Supreme Court will act as an acting President. Okay, when office of President is vacant, then Vice President will act as a President. Okay, when office of Vice President is also vacant, then Chief Justice of India will act as a President. Okay, so acting President till the new President is being elected. Okay, so what I was talking? Resignation, yeah. He'll give resignation to Vice President. Then removal. How to remove the President? What is the process is called? Impeachment. In Kannada it is called as Mahabhiyoga. Impeachment. I told you what is the majority required here? 2/3 of total strength. Okay, 2/3 of it is not special. It is not absolute. It is only this kind of majority, 2/3 of the total strength. You will never come across 2/3 of the total strength.
only at the time of impeachment.
Yeah, this is the only case you need 2/3 of the total strength.
150
No. 2/3 of the 2/3 of the total strength. I said 300 is the number. It is just for your reference. Yeah, 2/3 of the 300 means 200 plus 1. 2/3 of the total strength, not present and voting. If in the house, if 200 members are present, all 200 must vote in favor of the resolution. Right? 2/3 of the total strength. This is the only case where you need 2/3 of the total strength. Special majority is 2/3 of the members present and voting. That should be more than half of the total strength. Understood, na? Here not 2/3 of the present and voting. It is 2/3 of the total strength. ಅರ್ಥ ಆಯ್ತಲ್ವಾ? Not everyone, 2/3 of the strength. 2/3. Okay, so it is the only case. Don't get confused with special majority. Okay, special majority is 2/3 of the present and voting. Okay, yeah, I'll tell you the procedure how to impeach a president. So to impeach or to remove a president, a resolution has to be passed in parliament, both the houses, in Lok Sabha and Rajya Sabha separately. Okay, Lok Sabha and Rajya Sabha separately must pass a resolution with this majority. And one more thing is, while election of a president, nominated members will not participate. But in impeachment, nominated members will participate in voting. Okay, they will not come for election. For removal, they will participate. Both elected and nominated members. Okay. So in Rajya Sabha, there are 12 nominated members. No, they will vote in case of impeachment of the president. Okay. So the procedure is, if the resolution is introduced in Lok Sabha or Rajya Sabha, 1/4 of the members must sign it. Okay, 1/4 of the total strength of the house. 1/4 of the members must sign the resolution and hand it over to speaker or presiding officer of the house. Speaker in case of Lok Sabha, chairman in case of Rajya Sabha. They must sign the resolution and they must give it to the presiding officer. That is speaker or chairman. Okay, the speaker or chairman can accept it or he can reject it.
It is also total strength,
Yeah, 1/4 of the total strength. Yeah. Suppose if there are 300 members, say 400 members, 100 members must sign the resolution and hand it over to speaker. Resolution matlab means this is we are introducing a proposal for remove the president and with the signatures, and they should hand it over to speaker. Okay. If speaker accepted, a 14 days notice has to be given to president. Okay. 14 days notice has to be given to the president. Then president can defend himself in the house. He can send a lawyer or someone to defend himself in the house when the resolution is under discussion. Okay, the resolution will be put to discussion. The members has to discuss what is the reason for removal of president or what are the grounds and all. The discussion will happen. Then the resolution will be put to vote. Once it is put to vote, then it has to be supported by 2/3 of the members of the total strength. If the resolution is introduced in Lok Sabha, 2/3 of the members supported the resolution, okay, then the resolution is being passed in Lok Sabha. Then it will go to Rajya Sabha. If the Rajya Sabha also passes with the same majority, 2/3 of the total strength of Rajya Sabha, then the president is removed. Okay, that is called impeachment process. Till now, no president has been removed. Okay, impeachment resolution has never been moved in Indian Parliament.
one person will only resolution in Lok Sabha, but not in Rajya Sabha, means then also.
Rajya Sabha, if the resolution is not passed in Rajya Sabha, then president will not be removed.
Here, if the resolution has to be passed in both the houses
Separately.
by the different houses separately.
Yes.
Only in the Lok Sabha that will this resolution is passed, but not in the Rajya Sabha.
Then president will not be removed. Impeachment resolution has failed.
Okay.
Both the houses, if it is introduced in Rajya Sabha, then it will come to Lok Sabha. Lok Sabha also should pass it with same majority. Then president will be removed. If Lok Sabha rejected it, then president will not be removed. If Lok Sabha passes, then the resolution will go to Rajya Sabha. If Rajya Sabha rejects it, then the bill ends there. Resolution ends there.
Resolution is given by both the houses, only one resolution, right, sir?
Yeah, first, see, it can be introduced in first house, okay? Say Lok Sabha, this is Rajya Sabha, okay? The resolution can be introduced directly to Lok Sabha or it can be introduced directly to Rajya Sabha. It is a choice of the members. If it is introduced in Lok Sabha, if Lok Sabha rejects, the resolution ends there. The president will not be removed. If Lok Sabha accepts it, then the resolution will go to Rajya Sabha. Okay? If Rajya Sabha approves it with or passes the resolution with 2/3 of the total strength, then the president will be removed. If Rajya Sabha rejects it, the resolution ends there. Clear? Both the houses has to pass it separately. There is no concept of joint sitting.